You are listening to the Aging Starts Now podcast, where it's all about responding with confidence to the legal, financial, and personal challenges created by a disability, unexpected illness, or aging in general. Join us weekly as elder law attorneys Barbara McGinnis and Chris Johnson, along with other members of the Johnson McGinnis Elder Care Law and Estate Planning team, talk about the tools, techniques, strategies, and services that will make the elder care journey easier for everyone involved. Get ready, because aging starts now.
Hello, and welcome to another episode of Aging Starts Now. I'm Dana Henschel, the Outreach Coordinator, and today we are answering some frequently asked questions about trust. Joining me for today's conversation is attorney Josh Hunter. Welcome, Josh.
Hi, Dana. Thanks for having me.
So one common question that we get is kind of the difference between a revocable and a non-revocable trust, or just the differences in trusts in general.
Oh, sure. I think that's something that trips people up frequently. And it's easiest to tell the difference between how they work and what their goals are, right? So starting with a revocable trust, generally the main goal of a revocable trust is probate avoidance, right? It doesn't provide asset protection. It's not going to provide some separation between you and your creditors, but rather making things easier to administer when you ultimately pass one day. So ease of administration with your estate and that probate avoidance. In regards to how it functions, it's rather flexible and easy to use. So with a revocable trust, or rather any trust, let's take one step back. There are three main positions with all trusts. There's the grantor, the individual who creates the trust. There's the trustee, the person who manages the assets that are in the trust for the beneficiaries. And then finally, there are the beneficiaries. And that could be separated between who is to receive benefit for the person's lifetime or after the grantor has passed away. So talking about a revocable trust, usually the individual who creates the trust, the grantor, has all three of those roles. That's why it's so flexible and easy to use. The grantor is the person who creates it. The grantor is in control of their assets and usually acts as their own trustee. And then oftentimes, so long as the grantor is alive, those trust assets are used for their benefit. And so sometimes we'll even jokingly call it the hokey pokey of trusts, right? You can put stuff in it, you can take stuff out of it, it's easy to use. Now, that helps you achieve that probate avoidance, but since you're still fully in control of those assets that are in a revocable trust, you don't get asset protection, you don't have adverse tax implications. Now, alternatively, let's swap to the irrevocable trust. This is a less flexible trust, and this can allow you to have asset protection. And how does it do that? Well, in short, the grantor doesn't hold all three of those roles anymore. So the grantor is still the person who creates the trust, but oftentimes someone else acts as the trustee and someone else is the beneficiary. And this allows you to get that asset protection by separating control. So with less control, you can achieve that asset protection.
Right. So you can't have everything. I mean, there's pros and cons to both. And we have callers that call in and say, I need a trust. I need to get on Medicaid. I was told that I need a trust, or I need to protect my assets, so I need a trust. And the answer is a trust is different. And there are different types of trusts, and it depends on what your main goals are, because some people want the asset protection, yet they don't want to lose control. So you've just got to figure out, what do you want most?
Right. What's going on in your life? At what stage are you? Are you someone who's 30? Are you someone who's in their 50s or approaching retirement age? Or are you someone who's facing care expenses or has a diagnosis to where future expenses scare you and asset protection is more viable for your situation? I had someone once tell me that a trust is one of the greatest creations of the human mind. They can do so many different things, from probate avoidance to asset protection to helping you qualify for Medicaid and TennCare if you have excess income. all the way to those famous and popular TV show style legacy trusts when people have, tons of money they're trying to manage. There's so many different goals and different trusts to help achieve those goals.
Right. So that's why I think it's important to see an attorney. As we say here all the time, you're not paying for the document, you're paying for the advice.
Right.
And so that's why paying for a professional is always more beneficial than just downloading a form.
That's right. Because that form, the form you download is not able to tell you whether it's appropriate for your situation or not.
Right.
And you may or may not know some of those ins and outs. Exactly.
So once you get the trust paperwork created, are you done?
No, even though many people unfortunately believe that you are, right? It feels good to get those documents signed and get things rolling. But no, it's not done. That's why we kind of use a bucket as an analogy for the trust. A trust can only protect and guide what assets you put inside the trust or inside that bucket. If there's nothing in it, it doesn't actually do anything. Another legal phrasing for that is known as a dry trust. When it's unfunded, all you have is a sheet of paper. So you have to make sure you get assets inside of that trust by maybe deeding property into the trust, retitling accounts into the name of the trust, or maybe making those payable on death beneficiaries. That way your trust can actually administer your wishes the way you were hoping it would. But if you just leave it as a signed document with nothing in it, nothing's going to happen.
It's a worthless sheet of paper. Is that what you're saying?
That's what I'm saying.
Okay. And can you do this yourself, or do attorneys help you fund your trust? I mean, is it easy or complicated, or I guess that depends on the assets?
It sure does. You actually walked right into the answer there at the end. I would say it really depends on the complicated nature of your estate. Someone who may just have one bank account, it's pretty easy to change a beneficiary on one bank account. Maybe they can manage that if they know they need to do it, right? But I think it just depends on how the law firm you're working with works. So here at our firm, as you well know, we like helping our clients ensure that that trust isn't left empty. So we guide them through the trust process. It can be complex. Should you deed your property into the trust, and when should you do that? Do you still have a mortgage on that? And that question could really change the answer to what type of trust you may use. Should you retitle the account or just make it payable on death? Or why would you do that rather than just make it, your bank account payable on death to your children? Well, your trust can add protections that making something directly payable on death to your children cannot. So I'm always an advocate for that guidance along the path rather than just setting somebody off to do it on their own. Because if you make a mistake with a trust, you've likely invested a good chunk of money into establishing the trust to achieve a goal, and then it wouldn't work, right? So I think advocacy over time is more favorable.
Right. So another question that we get is people who go to their banks, and then the bankers are looking for a trust number or EIN number. Mm-hmm. Can you speak to that a little bit?
Sure. So really what that entity is asking you for, or that financial group, is trying to figure out what's the tax ID number for your trust. So a trust is a standalone legal entity in its own right. And sometimes it pays taxes as its own legal entity, just like you and I. And other times taxes are passed through to the people who created the trust or are managing it. But the idea is if you're dealing with a revocable trust, the tax ID number is the same as the grantor's. Because remember, like we said with the revocable trust, the person who creates it has all three roles. They're the grantor, the trustee, and the beneficiary. They're controlling it in every meaningful way. So the taxes are on their Social Security number. It's their stuff. Alternatively, with an irrevocable trust, right, we've separated assets from the control of the grantor. That way we can achieve that asset protection likely. Those trusts have their own tax ID number. That's what the EIN is. And that comes from the IRS. That's a trust tax ID.
So how do you, just as an individual, write to the IRS and say, I need an EIN number for my trust? Or is that something that the attorney drafting the trust does?
Right. Well, here at our law firm, we help our clients get that trust ID number. I'm assuming most law firms, they're helping you create this trust, do the same, because it's not a lengthy process. It's not crazy to get. You can obtain that tax ID number from a trust online, through the IRS website, and the application is pretty seamless. It's not complicated to do, and filing and working on the form online allows you to submit everything virtually. So that's easy and helpful. And they'll receive the application online and perform validations, make sure everything is squared away, make sure they understand who the trustee of that irrevocable trust is. And then they return with a 9-digit unique IRS number, right? That EIN number. And frankly, it can take less than 10 minutes to do it. So oftentimes I would think the law firm that's helping you create that irrevocable trust will do it. Now, if you have a revocable trust and you're using the grantor's social security number, that's fine. But remember that can transform when the grantor passes away. So when that happens, that trust will likely become an irrevocable trust when the grantor has passed. And then you'll need to go pick up an EIN for that too.
Okay, you just answered my next question. That's what I was curious about.
Yeah, it can come up later.
Okay.
But the IRS wants to make sure everybody's paying their taxes owed. And so with a revocable trust, it's the person who makes it most of the time. And with an irrevocable trust, it's either the trust is paying their own taxes or something to that extent. So that's why they need their own number.
And if your trust changes once the grantor passes from revocable to irrevocable, hence the need for the EIN number,
right?
Do you have to report that change to people, or is that something that just automatically happens?
It depends on how much business that trust is going to continue to do. Oftentimes, with a revocable trust, when the grantor passes, the backup trustee that's in that document is just emptying out the trust, right? They're just following through with distributing things and the trust closes. So there's really not any business or taxes to worry about, hopefully. But if the trust is open over an extended period of time and doing business, I would say, yeah, let those people who you're doing business with know that the grantor's passed, we've changed status. This is an EIN number if there are any taxes involved. It also depends on what's in the trust, right, to pay taxes. But that's how I would phrase it.
Okay. And who should have a trust? I mean, I think that there's a big misconception out there that, trusts are just for rich people. No?
We've both heard that then. I would disagree with that statement. I don't think trusts are only for the rich. I think trusts are a tool that can help you achieve a goal. And depending on what your goal is, if that goal is best achieved with a trust, then you can do that. If a family that is not rich by any means is trying to avoid probate, well, a revocable trust can be a very effective tool to do that and can make working with the administration of an estate after your passing easier. And if that's your goal, that can help you achieve that goal where a standard will could not. If you're trying to protect assets because you're worried about long-term care expenses down the road and how to preserve what you have and asset protection, a trust can be a great tool for that. That may be the irrevocable trust, depending on what you're trying to do. Right. Or if you're considering legacy planning and you're trying to make sure your assets are utilized in the way that you hope after you're gone, well, a trust can help you memorialize those wishes over time too. I'm not sure if you know, but Tennessee allows a trust to technically survive for 360 years. So that's an impressive amount of dead hand control after someone has passed. But if legacy planning with strings attached is important, then maybe considering a trust is best for that person too. It fits many situations.
Okay. Wow. And just quickly, I think people throw around the word probate and we want to avoid probate, but they don't really even understand what probate is.
Right.
So can you give just one or two examples of why someone might want to avoid probate?
Sure. So probate isn't necessarily a bad thing. Probate is a tool. And every good craftsman will tell you that a good tool used at the wrong time is still the wrong tool. And so probate is when someone passes away and they need to either effectuate a will, right? You have to go through probate to do that. Or if someone passed without a will or any other document, it's a court supervised administration of your estate. And while that can be okay, the biggest three downsides that we often see is that it can be costly to the families to work through a court process and utilize an attorney. It can be time consuming, where lightning fast probate in Tennessee can be between 6 and 8 months on the best of cases. It can be longer than that when things go wrong. And one thing that really makes people upset with the probate process or prospective is that your information and your wishes, your estate, your inheritance is public record. A rough idea of what your estate is worth and who is going to receive from your estate is public record. And sometimes that can bring out the sharks and nefarious people who watch those sort of things. And frankly, who's getting what out of your estate's no one's business. So those are three potential downsides to probate. Not that it's bad, it can be used in a good way, but those are three things you may want to avoid.
Well, thank you, Josh. It's always great talking to you about these things. And those are the questions that I hear the most. Can you think of anything else that you hear commonly when it comes to trusts that we've missed?
No, I really think you've done a good job of pulling these questions together. It's the stuff we often hear. If I was finishing with any last statement, it would just be that rather than worrying about what document you think you need, I think it would be more beneficial to consider what your goals are and then get adequate advice to figure out what's the best way to achieve that goal, rather than just focusing on the document or what you may have heard that document does.
Exactly. Well, thank you, Josh. Johnson McGinnis Elder Care Law and Estate Planning is a life care planning law firm helping families respond to the legal and financial challenges caused by chronic illness or disability of an elderly loved one. Join us next week for another episode of Aging Starts Now.
Thank you for listening to the Aging Starts Now podcast. For more information about today's show, visit tn-elderlaw.com, click on the Free Resources tab, and then click on Aging Starts Now. You'll find the show notes there. And while you're at it, why not check out all the free resources available at tn-elderlaw.com. Document downloads, the Johnson McGinnis blog, educational videos, informative articles, helpful links, a TV show, and more. It's all there, free for the taking. If you enjoy listening to the Aging Starts Now podcast, please subscribe, rate the show, or leave us a review. It's easy to do on whatever app you use to listen. We would love your feedback on the show. Aging Starts Now. We'll be back next week with more candid discussions about the challenges created by aging, disability, and unexpected illness.